Supreme Court targets gun permits nationwide. Across America, your right to carry a firearm could change forever, not through Congress, but by a single decision from the highest court in the land. The Supreme Court has just granted review in a case that could wipe out permit systems in every state. This isn't speculation, it's real, it's official, and it's happening now. At the center is a legal battle out of Hawaii known as Wolford versus Lopez, and its implications are explosive. In this video, we're going to break it all down, what the Wolford case actually argues and why it challenges all permit systems. Why the Ninth Circuit's ruling triggered national alarm for gun rights advocates. How the Bruen decision is being used to demand permitless carry. What this could mean for shall-issue states, training laws, and permit schemes. What happens next now that the Supreme Court has stepped in? Welcome to Firearms Law Advisor, where the Constitution is never up for debate. Stay ahead of the fight. Like this video and subscribe now. Chapter 1. Case that could end permits forever. It all started with a woman named Lori Wolford in Hawaii denied her permit to carry even after meeting every requirement. Her challenge wasn't just personal, it was constitutional. And her case, Wolford versus Lopez, is now set to decide whether any permitting system survives under the Second Amendment. The Supreme Court's decision to grant review marks a turning point in how firearm rights are evaluated nationwide. Key takeaways: Wolford met all training and legal criteria, but was still denied a permit. Hawaii's system gave the police chief complete discretion, even without a criminal reason to deny. The Ninth Circuit upheld this denial, claiming it passed constitutional muster. Gun rights groups argue this violates the Bruen standard, which requires historical precedent. This isn't just about Hawaii. Dozens of states operate similar discretionary or shall-issue systems. If the Supreme Court rules these violate the Second Amendment, the ripple effect could dismantle permits across the country. Chapter 2. How Bruen changed the game. The 2022 landmark decision in New York State Rifle and Pistol Association versus Bruen set a bold new standard. It declared that any modern gun regulation must align with the nation's historical tradition, not just modern interests or government preferences. And that's exactly why the Wolford case matters. Hawaii's law has no roots in early American tradition. That alone could make it unconstitutional under the Bruen framework. Key takeaways: the Bruen test replaced intermediate scrutiny with historical analysis. Modern gun laws must match regulations from the 1700s to the 1800s. New York's proper cause requirement was struck down in Bruen. Wolford's denial mirrors the same subjective discretion struck in Bruen. If Hawaii's permit denial lacks a historical equivalent, the law fails just like New York's did. And if Bruen applies nationwide, Hawaii won't be the only state forced to repeal its system. Chapter 3. Why Ninth Circuit's ruling raised alarms. The Ninth Circuit ruled in favor of Hawaii, calling the state's permit denial reasonable. They argued Wolford didn't suffer a constitutional violation because she technically had a legal path to apply. But critics say this is a direct evasion of the Bruen precedent and a roadmap for states to delay or deny rights through bureaucracy. Gun rights groups quickly asked the Supreme Court to intervene, and now it has. Key takeaways: the Ninth Circuit ignored Bruen's focus on historical tradition. It treated permit processing delays and denials as minor issues. The court claimed there was no constitutional harm since the system exists. This approach invites abuse by states that don't want to comply with Bruen. The Supreme Court's review suggests serious disagreement with the Ninth Circuit. If they reverse the ruling, it would be a major blow to states resisting the Bruen standard. Chapter 4. What's at stake for shall-issue states? Most American states operate under shall-issue permitting systems. This means if a citizen meets all legal criteria, the state must issue the permit with no discretion involved. But even these systems often require training, classes, applications, and delays. Wolford challenges the very concept of needing permission to exercise a right. Key takeaways: shall issue doesn't mean no restrictions. It still involves government control. Some states impose high fees, long wait times, and invasive background checks. The Supreme Court could decide that any required permit violates the Second Amendment. If so, it would force states to adopt permitless carry or rewrite their laws entirely. This isn't just a question of Hawaii's system. The entire concept of permit to carry is under legal fire, and Wolford could be the vehicle that burns it down. Chapter 5. Will this decision affect blue states most? States like California, New York, New Jersey, and Maryland have a long history of strict gun control. After Bruen, these states tried to find workarounds, creating sensitive place restrictions and imposing training mandates. Now, Wolford could blow those workaround strategies apart, because the core question isn't whether you follow rules, it's whether the rules are allowed at all. Key takeaways. Blue states heavily rely on bureaucratic permits to limit carry rights. They often use training, insurance, or sensitive language to restrict citizens. If permit requirements are struck down, these frameworks collapse. Even good moral character clauses could be deemed unconstitutional. States with tight gun control are watching this case closely because their entire model depends on upholding permit requirements. A ruling against Hawaii may set the precedent that destroys them all. Chapter 6. Federal judges sound the alarm. Under Bruen, gun laws must reflect the historical tradition of the Second Amendment, but the idea of needing a government-issued permit to carry a weapon is a relatively modern concept. Gun rights groups argue that in 1791, when the Second Amendment was ratified, there were no such permit schemes in place. That historical vacuum could be the nail in the coffin for today's carry laws. Key takeaways. Colonial and early American law did not include firearm permit requirements. Citizens were expected to bear arms as part of civic duty, not government approval. The Supreme Court has emphasized founding-era analogies in its rulings. Permitting systems are a 20th century invention, unsupported by 18th century precedent. If Hawaii's permit scheme can't find historical support, it fails under Bruen. And if Hawaii's law fails, dozens of others fall with it. Chapter 7. Ninth Circuit's surprising silence. At its core, this case is about more than policy. It's about the right to defend yourself and your family without state interference. Permit systems often delay or deny that right entirely, especially in emergencies. And when states hold the power to decide who is worthy of self-protection, the Constitution takes a backseat. Wolford versus Lopez challenges that very imbalance. Key takeaways. Permits can take weeks or months, leaving people vulnerable in the meantime. Some states charge high fees, making carry inaccessible to lower-income citizens. Authorities often deny permits over subjective or political concerns. A ruling in favor of Wolford would restore immediate self-defense rights nationwide. This case could reaffirm that your rights don't require approval. It would strip states of the power to delay or deny lawful carry, especially when seconds matter. Chapter 8. SCOTUS sets national stage. If permits are struck down, law enforcement will face a new landscape. Officers will no longer be able to rely on permit databases to verify who can legally carry. But proponents argue this shift could actually improve clarity because rights would be presumed, not denied by default. And constitutional rights shouldn't depend on administrative convenience. Key takeaways. Police often use permits as quick checks for lawful carry that would change. Training and education programs may shift to voluntary models, not mandates. Officers would have to rely more on criminal records, not permit status. Some departments may push back, but others support clear-cut rights enforcement. This would be a culture shift, not just a policy shift, but one that prioritizes freedom over bureaucracy and clarity over control. Chapter 9. What could replace permit systems? With permits potentially on the chopping block, states may look for alternatives. Some may implement optional licenses for reciprocity or background clarity. Others may focus on universal background checks at the point of sale, rather than carry control. The future will depend on how broadly the court rules and how states respond. Key takeaways. Optional certification systems may replace mandatory permits in some regions. Training courses could continue, but not as prerequisites for rights. Constitutional carry may become the national standard by default. States could shift restrictions to sensitive places or purchase processes. Wolford doesn't mean chaos. It means resetting the balance toward individual responsibility. States can still protect public safety, but not at the cost of fundamental rights. Chapter 10. What this means for gun owners. Now that the court has agreed to hear the case, the timeline is set in motion. Briefing schedules, oral arguments, and nationwide amicus filings will follow. A decision could come as early as late spring or early summer, right in the heat of election season. And the ruling could be one of the most impactful Second Amendment decisions in decades. Key takeaways. The court granted review in October 2025, signaling high interest. A final decision could be issued by June 2026. Gun rights groups are mobilizing amicus briefs to support Wolford. A win could trigger immediate lawsuits against other permit-based states. This is more than a legal fight. It's a national moment of reckoning, one that could restore the right to carry for tens of millions of Americans. End of firearm permits? The Supreme Court doesn't take just any case. When they agreed to review Wolford versus Lopez, they sent a message to every state. The days of controlling constitutional rights through bureaucratic permission may be numbered. And if this decision mirrors the impact of Bruen, we could be looking at the end of all mandatory carry permits in America. For gun owners, this is a moment of opportunity and a moment of risk. The ruling isn't guaranteed, and the legal opposition will be fierce. But one thing is clear, the court is listening, and the Constitution is speaking louder than ever before. Stay informed, stay ready, and stand for your rights. Subscribe to Firearms Law Advisor for real. Expert breakdowns on every legal fight that shapes your freedom. This is not about politics. This is about power. And who gets to say when you're allowed to defend yourself? We say the Constitution already did.